Good morning or good afternoon to wherever you are joining from today. My name is Dan Johnson. I'm the Director of Marketing here at myHRcounsel, and welcome to this week's edition of the myHR Minute. We appreciate you taking the time out of your day to join us and for your continued interest in our weekly webinars. As a reminder, as always, we will be recording this webinar, and we will send a follow-up email with the recording, the slide deck, as well as the HRCI or SHRM recertification credit codes in an email tomorrow. Additionally, we'll be sending a link to a survey. We would really appreciate you taking the time to complete. The results of this survey will help improve our weekly webinars and will also allow you the chance to recommend new topics for our weekly webinars that we potentially have not yet covered or you would like more information on. And now I'd like to introduce our speaker for today, who is Britt Waterman, who's a senior attorney here at myHRcounsel. Thank you, Britt.
Thanks, Dan. Well, welcome everybody to our myHR Minute webinar today. We're going to talk about breaks, about federal law on breaks. I know many of you know that your state law kind of tells you what to do, but we're going to talk about some of the dispelling some of the myths and getting compliant with breaks with regard to federal law today. So we can start off with the first slide here. It's actually the third slide in our deck. Dan has the slides. So federal law does not require breaks. And that there is no federal lunch break law. The 30-minute meal break is law in some states, and some for some employers it's just kind of a tradition to give a 30-minute meal break. That is not federal law. If your state did not make a break law, and there are plenty of states whose law is silent on breaks, you can tell your employees that they must work from clock in to clock out without stopping. Inevitably, there may be some hitches in your plan, as we'll get to discussing, but you can make that rule if your state does not have a break law. But employee morale is important. How are you going to attract and retain top talent if you are known for having a no break policy? Having a no break policy or a very restrictive break policy is a really good way to get your employees to organize against you. So just something to keep in mind. So federal exceptions, like I said, there is no federal break law. You do what your state says and you're good, but the federal law has some exceptions for you. Even where you think your state has a generous break law, you may still have to go above and beyond. It's not a free-for-all, and federal law will trump state law in these cases. So whatever law is the most employee friendly or gives the employee the most protection is the law that goes. So what about paid breaks? This applies no matter what your employees are doing with the break. So employees must be paid for every break that lasts fewer than 20 minutes. So the solution is to control break time or discipline employees for leaving their work area without permission, not make them punch in and out when they want to take a break. If you don't want your employees leaving your premises, make a policy and discipline them if they break it. Do not make them punch out for a 15-minute break if they want to go to the convenience store across the street instead of staying in your break room. If an employee takes an unauthorized 10-minute break, your solution is to discipline them, not to dock their pay by 10 minutes. Have a strict break policy and use discipline. Not paying your employees is never an appropriate punishment. If you've been making your employees punch in and out for breaks less than 20 minutes, you can make it right with the DOL by paying all of those employees for all of the break time they should have been paid for by the last 3 years. Otherwise, you start doing it now and hope you don't get a wage and hour complaint. This applies in every state, whether they require breaks or not. Your state may not require you to give rest breaks, but if you decide to be more generous than state law and give your employees rest breaks, federal law says that you pay them for rest breaks of fewer than 20 minutes, and you go with the law that is most employee friendly. So moving on to unpaid breaks. This is where the 30-minute lunch comes from. So 30 minutes is the shortest amount of time you can let your employees take a break without having to pay them. Now, in order for employees to be unpaid, they must be relieved of all duties. So an employee eating at his desk, having to read emails if they pop up, is not relieved of all duties. If an employee is a front desk employee and they have to put their sandwich down if a guest comes in, they are not relieved of all duties. You would have to pay these employees for their meal breaks, even though they are eating a sandwich part of the time during those 30 minutes. If your employee is the only security guard in a booth and no one can come in to relieve him during his shift, you cannot give him an unpaid meal break, even if he eats his lunch peacefully and no one comes to the booth for 30 minutes. He is on duty the whole time. The best way to avoid inadvertently having to pay for a meal break, is to have a break area and encourage employees to take meals away from their workstations. Some states require a meal period relieved of all duties, but will make exceptions for working lunches. Some states require a place to heat and cool food for meal breaks. Some states do require that employees be allowed to leave the premises during their meal break. You have to know your state, but federal law requires that the employees be relieved of all duties for the break to be unpaid. And the next slide is something I hear about all the time: smoke breaks. I hear non-smokers complaining they don't get as much break time as smokers. Smokers do not have a special right to breaks. Do what your state requires. You do not have to allow smokers to get more. In states that require rest breaks, you cannot ban smokers from taking any rest breaks just because you think they will be used for smoking. But you can make a no tobacco use policy that prohibits all tobacco, nicotine, vaping during the workday. If you have customer-facing employees, maybe you don't want them to smell like smoke. There's no law that says you have to let them smoke. There are some states that says employees have to be allowed to leave the premises for a meal period to be unpaid. Then they can leave the premises and be unpaid. That's their time. This does not apply to rest breaks, because rest breaks are paid. When you are paying your employee, you get to tell them what to do. If that means staying on the premises to take a paid rest break, that's up to you. If you want to tell your employees, no smoke breaks, or no going above and beyond what the state says, you can do that. You do not have to let employees go out and have a cigarette if you don't want to. So most states have a legal off-duty conduct law, which says you can't discriminate against tobacco users. So you can't refuse to hire somebody because they smoke off the job and you think they're going to ask for more breaks. But those are off-duty conduct laws. They don't tell you what to do on duty, which on duty you can make your own rules about smoke breaks. Smokers do not have to hold you hostage when it comes to breaks. Bathroom breaks. You are not the arbiter of how long it takes someone to go to the bathroom or how often someone has to go. Don't spend a lot of time thinking about this. If you have a no cell phone during work time policy and employees are making long personal calls in the stalls, that's a disciplinary problem, but generally stay out of this. You don't need to open up the door on bladder, bowel, feminine hygiene issues if you don't need to. If it is notably lengthy or frequent where work is being packed in, don't jump to negative conclusions. Let's move on to the next slide. A frequent ticket I get has to do with employee who is taking excessive bathroom breaks. First question, can we ask if it's medical? You can tell your employee that you've noticed the employee having difficulty performing the functions of their job because of the additional time spent using the restroom, and tell them you want to provide a reasonable accommodation. They may be embarrassed, but you can tell them we need to provide the reasonable accommodation to accommodate the additional time away from the desk. Be sensitive. usually I would not tell a diabetic employee, oh yeah, you can step away from the line to go grab a snack, whatever. Go through the interactive process and document the whole thing. What happens when they get a new manager or you're replaced? Just a verbal okay might be ignored. You don't want their break to get skipped one day and for them to sue you because you have no documentation. Don't tell a frontline supervisor why an employee needs a snack break or a bathroom break. Just order the frontline supervisor to accommodate the break. The break has to enable the employee to perform the essential functions of the job. If they can't do the job, even with the break, it's not a reasonable accommodation. But go through, be sensitive, go through the interactive process, and determine a reasonable accommodation, which may be longer bathroom breaks or a snack break or a water break or something like that. But make sure you're going through that process and documenting the whole thing. Pregnancy accommodations, so these are protected under the Pregnancy Discrimination Act. Additional bathroom breaks or rest breaks are very common accommodation. You cannot consider the effect on morale of your other employees, feeling like a pregnant employee doesn't need a break. You can't consider your other employee's opinion. You also can't tell a pregnant employee to go sit down because you're concerned about the health of her fetus if she stands too long. So while you have to accommodate additional breaks, if a pregnant employee needs additional breaks, you also can't make a pregnant employee take a break. You can't say you need to take a second meal break because we're trying to help. The accommodation request must come from the employee. You can request medical documentation for the accommodation request, but the employee does not have to tell you she is pregnant. She can make a reasonable accommodation request like any employee with a disability with medical documentation, and she does not have to tell you she is pregnant, but under the Pregnancy Discrimination Act, you must accommodate things like additional bathroom breaks or rest breaks. And lactation breaks. Lactation breaks were made federal law by the PPACA, also known as Obamacare. Now they are governed by the Fair Labor Standards Act. Reasonable unpaid break time means that when the employee has to pump, they have to pump. You cannot tell them, hey, rest break is scheduled for 10:30. You've got to wait until 10:30 to pump. But if all employees get a 15-minute paid rest break at 10:30 and the employee pumps for 30 minutes at 9 o'clock, you don't have to give them another 15 minutes at 10:30. You can count 15 minutes of that pump time as the paid 15-minute break. You just have to compensate a lactating employee for break time the same way you compensate other employees for required breaks. Georgia, Illinois, and Minnesota require paid lactation breaks. You should if you're in these 3 states, you should be paying nursing mothers for all of the time spent pumping. California says you need to go 3 years from the child's birth. Federal law says 1 year. Even if your state law does not require a refrigerator and an electrical outlet for lactating employees, let's be reasonable. Let's set them up. Well, it has state or federal law requires it has to be somewhere other than a bathroom, but make lactation accommodations, give them somewhere decent, and try to support nursing mothers. Or you may have a sexual harassment or a gender discrimination claim on your hands that has nothing to do with this. So be reasonable when it comes to setting up lactation breaks. So that is the conclusion of our myHR Minute. If you have other questions about breaks or questions about any other HR or employment law issues, if you are one of our clients, you can certainly open up a ticket in the Ask HR system. In the Ask an Attorney portal. If you are not a client and you would like more information, you can go to myHRcounsel.com or you can email info@myHRcounsel.com. We'd be happy to talk to you more about how to become a client, how to have your HR and employment law questions answered by a licensed attorney, questions like what we went over today, or anything under the sun with HR and employment law. So our packages include unlimited legal advice on demand, really helpful when it comes to questions like breaks. Like I said, these are tickets that come in all the time, questions I get from clients all the time. Like I said, if you have questions, open a ticket. Otherwise, myHRcounsel.com or info@myHRcounsel.com.